Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. If you filed a lawsuit, you can be certain that the defendant will conduct some research on your background. They're looking for something that they can use during discovery, particularly in the deposition. There may be something in your background, your record, that could potentially give the appearance that you were engaged in a crime or criminal activity. Whatever it is, you have the right to plead the fifth. And I want to look at the deposition today and the deponent's right to plead the fifth when the defendant propounds a question that would usher in a response that even by appearance would make the deponent look guilty. So let's get started. So let's look at some Fifth Amendment protections. The Fifth Amendment states in part, no person shall be compelled in any criminal case to be a witness against himself or herself. The Fifth Amendment protects criminal defendants from having to testify if they may incriminate themselves through the testimony. A witness deponent, a person giving their deposition in a civil lawsuit, may plead the fifth and not answer if the witness believes answering the question may be self-incriminatory. So let's look at some pros in invoking the fifth. The privilege, as we said, protect the witness from answering specific allegations, for example, in a complaint, if the answer would violate the witness's rights under the privilege. Another pro, refusal to testify cannot be used against the witness taking the deposition. It protects the innocent and the guilty. Let's look at some cons. A lot of times, deponents will not or do not feel comfortable invoking the fifth because they're concerned that it may make them look guilty. Now, keep this in mind. Even if a deponent goes to trial as a result of the litigation, the jurors are instructed not to make an adverse inference as a result of the deponent invoking the fifth. But let's just be real, okay? Jurors are people like you and I. So even though a juror may be given an instruction by the judge not to make an adverse inference as a result of the deponent invoking the fifth, sometimes people are just biased. I just want to be real with you, okay? So keep that in mind. Another con is the witness cannot use the fifth just because the individual doesn't want to testify. It has to be a situation where, as a result of the deponent invoking the fifth or not invoking the fifth and answering the question, they are likely to be prejudiced as a result of giving their testimony. Now, it is critical that the deponent witness make it clear whether they are or are not invoking the fifth, because failure to make it clear that the deponent witness is invoking the fifth could be deemed that the witness waive their privilege with regards to the questions on the same topic. The key is the deponent witness controls whether they're going to testify or respond to the matter raised by the defendant at the deposition. And some deponent witnesses have been caught off guard by the defendant asking such a question. And I would say to any pro se or plaintiff who files a lawsuit and you know that you have something in your record that would create this kind of dilemma, just be prepared. Prepare yourself ahead of time before discovery begins, and particularly when you give your deposition. You do not want to become fearful. You look at the pros and the cons and make a decision. Okay? Hey, you may have a criminal record and you may be pondering whether you should file a lawsuit. Don't let any such record deter you from seeking justice. I am Advocate Lucinda, your empowerment lawyer, and we will see you next time. Take care.